Hi, I'm Philip Hundl. I am an attorney and mediator. My practice area focuses on land disputes. So the mediations that I prefer as a mediator, and I want to talk about in this video session, are land dispute mediations like partition cases, condemnation, uh, eminent domain proceedings. So with that, I started this series and I promised to give the top 10 tips as I see them as a mediator to the attorneys, and also applies to the parties, but this is really probably more directed to the attorneys of what attorney you can do at, before mediation, at mediation, to give yourself and your client the best possible chance to get your case settled at mediation and have a successful mediation. We are at number three, and try to have titles to these to keep them as memorable as possible. And so pare down the issues. I always think about paring things down. The less that you have to fight about at mediation, the better. So as a mediator, if there are probably less things to have to deal with the parties, it normally makes the mediation simpler. Um, uh, what I mean by that is in the land context, for example, in a condemnation case, if it's a condemnation case or eminent domain proceeding by a pipeline company acquiring an easement, that mediation is going to deal with the easement terms. Possibly there's going to be, there's almost always dispute over the easement terms, but then also the monetary compensation. So you've got non-monetary terms that the parties are dealing with, and then monetary terms. Uh, the more that the parties, you attorneys, can whittle down and pare down the easement terms that you're, in disagreement on before the mediation, then more of the mediation can just be focused on the monetary portion or the monetary damage portion. So try to work on, attorneys, those easement agreements beforehand. Even if it's a fight over, it's a partition case and you know that one of the tracts that's going to be partitioned out and received by one of the parties, maybe at mediation, is going to need or going to have an access, road access easement, obviously. Uh, Try to get at least a form easement agreement for ingress and egress, road access easement agreement to the other side so that they can start working on it. What you don't want to do is at the 11th hour in a partition case, great, looks like we've got the division of the land agreed to. Wonderful. We spent all day doing that, and then all of a sudden, you know, someone throws a wrench in it by saying, oh, well, but no, the easement agreement needs to require that, your client or your party pays for all the road maintenance or whatever, or the number of gates in the easement agreement or the road access agreement, there's too many gates, or there is gates, or so. Try to whittle those things down beforehand and leave the mediation for obviously the things that couldn't get resolved or discussed beforehand, or just the parties are too far apart. Let the mediator focus on those things and not a lot of the little small details that are extremely important, obviously, or can be extremely important, but possibly could have been worked out before. And sometimes it comes down to, we're talking about road accesses and partition cases. It may be the location of this road access. Don't assume, right? We know sometimes when we say assume, that the access to the back track that sister gets is going to be accessed by this existing road. That may not be what's agreed upon, and so don't assume anything. So try to narrow those things down. Number 4 tip for successful mediation, land mediation, is bring authority to the mediation. Now, you may say, well, of course, that's, all the parties that, are parties to the litigation will be there. Well, and most of the time, of course they are, but in these larger, when there's multiple owners of a piece of property that, in an eminent domain case, may be owned by 4 family members. Um, the condemnor is gonna want all 4 family members, all 4 owners to settle the case. I doubt that they, in my experience, you know, condemnor is not normally willing to settle with just 3 and not the other one at a mediation, in a context of mediation. Um, and so if that mediation is set up to have all 4 of them there. Now, if you've got one client that is just absolutely refusing to go to mediation, then sure, a condemnor may say, fine, let's have a mediation with whoever, is willing to mediate, and let's settle with them. Do they oftentimes settle with some of the parties and not all the parties? Absolutely, sure. But once again, if there's going to be a mediation and everyone's expected to be there, make sure everyone's there. If they're not there because they can't be there because of the pandemic, because of, you name it, just general health and, in general, they can't be there, which will happen, then make sure that someone has authority for that person by and through a power of attorney or a limited power of attorney. Not uncommon, and this is not uncommon with, husband and wife. Sometimes, one can't get off work and the other one has really been involved with the litigation more than the other. Don't believe and assume that the spouse will assign for the other one. Make sure that spouse has power of attorney, or is their authorized agent under by and through a power of attorney to be able to settle that case. Now, can a party just attend, via phone? Sure. Less effective. Hey, we're doing Zoom hearings now. We're doing Zoom mediations now. I've been able to get some cases settled in a Zoom mediation. Yes. Still less effective than an in-person mediation. I'm still doing in-person mediations right now, just taking some precautions. And really what the clients feel more comfortable with. So make sure if you're going to mediation that whoever's there has authority. As far as, just the attorneys going when a client's unavailable, that attorney needs to have authority to settle the case. So, and I'll let the attorneys decide what they believe is necessary to settle the case, or what authority they think they need to settle the case. But make sure whoever's there has authority, and not reach an agreement that obviously someone can't sign because they don't have authority to. All right.